Vignette 4. Concerns about romance and the elderly.
So Saul and Emily, I like the progress that we're making. That's good. Small steps, right? And so I congratulate you on that. I know there is a big issue here about your mom and about her new relationship with Peter. Emily, maybe you can tell me a little bit, because you're around a little bit more. What's going on there?
Well, Pete, he's so nice. He's so nice to Mom. He shovels the snow. He does the gardening. Sometimes he picks up some groceries for us. He's really, really nice. And sometimes he comes in and watches TV. Mom likes the $10,000 pyramid.
Is that still on?
Well, we watch it on the special network,
okay.
And he's really good at it. And we really want to. Pete is so nice. Who's going to shovel the snow? Who's going to do these things? He takes in the garbage cans. It's a little confusing with all the different bins now.
Yes.
Yeah. So I mean I don't even know why we're talking about Pete. What does Pete have to do with anything today?
Okay, Saul, you've heard a little bit about Pete's help around the home. What's your concern about Pete?
Mom doesn't have capacity to make these decisions. I mean, if you talk to Mom, and I know you haven't, Jordy, but I have,
right.
She thinks he's dad. That's not good.
Right.
And she's not aware really of what's going on around her. I have no problems in watching.
You were in Florida the whole winter. Saul, you were in Florida the whole winter. You didn't come.
I called every week.
You didn't come. There was a lot of snow this year, Saul.
I'm sure he shoveled the snow, but we could pay someone $20 to shovel the snow. My problem is that you're at the casino, you're not there, the caregivers aren't paying attention to Mom. So during, when she's watching Pyramid and the rest, so how do we know, what are the checks here that he's not taking advantage of her, both emotionally,
right.
physically, and I don't really want to go down that road very much, but right. physically or financially? It's got to stop.
Right.
Why is it your business who's friends with Mom? She can have any friends she wants.
Well, according to you, it's not my business that you took $2 million.
Well,
okay, but let's see if we can focus here on Peter. So just so I'm clear on this, your concern is more the idea that Mom is vulnerable to influence, and you're concerned about financial
and she's
abuse?
Calling him dad.
Right.
Not dad. She's
right.
calling him Mel.
Right.
Right. So she's obviously not living in a world without delusion. And
right.
my concern is that I don't think it's healthy for Mom to have someone around all the time, especially when my sister's not there to supervise. What is he doing?
Okay, so let's try to see if we can. And I see your point, Emily, that your mom enjoys his company and likes having him around, right? I mean, do you see this example of him calling Peter your dad's name? Do you think there's some of that or not really?
I haven't seen it.
Okay.
I haven't seen it, and my brother couldn't have seen it because he's not here, so I don't know how he's seen it.
Right.
Okay. Yeah.
Do you have any concerns about Peter's intentions as far as financial matters, for example?
Peter has been our neighbor for 40 years. He used to own a restaurant. He's been retired now for a while. His wife has passed away. He's such a good neighbor. We really, really like him.
Okay. And has there been any kind of money exchanged with Peter?
There's $150,000 missing from last year.
Well, but we don't. Just let me.
For all I know, she's giving it to him.
Okay, but let's find out. Okay. So, is your mom giving money to Peter, or what?
Well, the only thing I'm going to say about that is we had to get a snowblower. So we got a nice one. Peter picked it out, and that's we had to get a snowblower. Yeah.
Okay. And but as far as
was it gold? Was it a gold snowblower?
I mean, I think that's a good question. Was it gold snowblower?
Jordan, are you really asking me that question? Because if you're asking
really.
that question, I'm going to leave.
No.
I'm going to leave.
You know what? It might not be bad for you to leave, actually. But before you do, Do you have any concerns about, like, does your mom, is it a romantic relationship that your mom's having with Peter? Do you know, I mean, is that the sense you have, or is it a business relationship, or what is it?
I think they're friends.
Yeah.
They're friends.
Yeah. Now, maybe...
Sometimes he has dinner with us. Yeah.
Right. Does he have kids?
He has 2 kids, but they haven't been around, kind of like Saul.
Gotcha.
I'm going into the snowblower business because apparently they're $150,000 a piece.
Maybe we can build in, if some of your concern is the protection for mom, maybe there's something that we can do similar to what we did with protection of the money for your mom, some protection that money does not flow to Peter. Is that something that you could see working?
But also too, maybe mom, I want mom to still enjoy life. That's not I don't want mom to be isolated. I don't want mom not to have friends. So if this is truly a situation where it's all just a friend and nothing more, then maybe that's the case. But where I have a real issue, and maybe we can deal with this about having some sort of expert come in and see mom, is her calling another gentleman caller dad.
Right.
Like, I don't think that that's healthy, and I don't know what that leads to, and I don't know, what he's doing in the house when we're not around. Maybe if she goes to see an expert, some sort of person who can be able to ask her questions about whether the delusion, like whether the person sees it the way that I do. But there has to be checks and balances. If she's around, if Emily's around all the time, then she can personally supervise. But I know that that's not the case.
But maybe the caregivers could be involved in that. Like, what do you think about that, Emily? The idea that maybe some professional advice would be helpful for your mom, just to get a feel for how she's coping. I mean, your dad, she just lost her husband of, so many years, and it can be very difficult. I'm sure you can imagine that, right?
Well, as Saul knows, my mom has a very, very nice family doctor. And he's been the family doctor for 40 years. And you know what? She doesn't have to go for more tests, prodding, this test, that test. She goes to her doctor regularly, and if he has any concern, he'll tell me. I take her to all the appointments, and you know what? Maybe Saul could come to one. I don't know. I'd have to think about that further.
Maybe I wonder if that issue just may be raised with her doctor, especially the fact that she has a long relationship with the doctor. That might make some sense, just to get some advice on that.
I'd be happy to go to the professional, whoever the professional is going to be, so that we're both there at the same time and we both hear the same thing and we can both ask the same questions.
This is beautiful. Look at that. You're to get a hug? What do you say? You ready for a hug?
I want the keys to the snowblower first.
At this point, I think we're going to turn it over to the real experts. The next panel. Charles Wagner is the chair of this one, and I'll introduce him. We all know Chuck, certified specialist in estates and trusts, regular speaker and presenter at seminars, the Law Society, the Ontario Bar Association, chair of the Estates and Trust Group, Lawyers Division of the B'nai B'rith. He's written extensively in this area and is the person behind this whole event, which is an incredible undertaking. I turn it over to Chuck to lead his panel.
Thank you, Jordy. Good morning, everybody. I'd like to introduce the panel who's with me. I won't make it too long of an introduction, simply because their profiles are in the binder. On my far right is Rabbi Mordechai Torczyner. He is the Rosh Kollel, the YU Kollel in Toronto, which mentors young adults, including young aspiring rabbis. And he leads a very interesting program for education for the Toronto Jewish community, including a CLE program, many CLE programs of value for lawyers. On his left is Andrew Felker. Andrew Felker is a certified specialist in estates and trusts. He is one of the foremost estate litigators in the Durham region. I like to call him the Prince of Pickering. and he is very well informed on the issues that we're discussing today. And I'm not talking just about this panel, but in the entire presentation today. On his left is Richard Coutinho of the Public Guardian and Trustee's Office. Richard is an excellent person to get to know if you're involved in this area of the law. I think the Public Guardian and Trustee does an excellent job. They're sort of like a 8-ounce cup where everybody's trying to pour 12 ounces of water into and trying to cope with a lot of they do. What many of you don't know, but if you take a look at his profile, you'll see he also has a master's degree theological studies from Harvard University. And since our respective panel is going to be dealing with the ethics of Section 3 Council today, I'm looking forward to his views on the topic. And on my immediate right is Marshall Swadron of Swadron Associates. Marshall is an expert in capacity in this area of the law of substitute decision disputes. And I also look on Marshall favorably because I see how well his practice worked out as a father and son. And since my son has now joined me in the practice, I'm interested to hear how it worked out from your perspective. Not today at the panel, but later. So I'd like to open up our questions with a question to Richard. Richard, if you could you give a quick intro to what Section 3 Council is and what role he or she may play in our fictional scenario today?
I think I'll begin by stating I do not speak for the Public Guardian and Trustee. I'm speaking for myself on many of these issues. And in keeping with that, I'd like to begin by stating how much I dislike the term Section 3 Council. The reason I dislike that term is because it suggests something extraordinary or unique, sort of like the Clarence Darrow or the Atticus Finch of the Estates Bar. And while it is a special role, and both Marshall and Andrew have served in that role, and they are special to me, certainly, it's not special in terms of the Act itself. The Act, and I'm referring to the Substitute Decisions Act, has a provision in Section 3 which requires the court, well, it doesn't require the court. The provision basically says that where capacity is at issue in a proceeding, the court may order the Public Guardian and Trustee to arrange for legal representation on behalf of the person alleged to be incapable. So in this scenario, clearly Selma Greenberg has capacity at issue, and it may be a helpful thing to have her counsel there. Now, one of the distinctive features about Section 3 Counsel is that Selma has no role in the selection of this counsel. It's my office, the Public Guardian and Trustee. And I'd like to ask all of you here, how many of you would like the state, and in particularly me as the agent of state, getting a counsel on your behalf, and moreover, having a counsel that you pay for? Section 3 basically also states that unless a legal aid certificate is issued, the allegedly incapable person, Selma, is responsible for payment of their fees. I'm guessing most of you wouldn't like that, and the reason that it is in our statute, I would suggest, is it is an extraordinary intervention for the purpose of having Selma's voice heard in this litigation. So far, we've heard from Saul on Selma's likes and dislikes. We've heard from Emily, but we haven't heard from Selma one iota. For all we know, maybe Selma detests the $10,000 pyramid on TV each day. But more seriously, this is litigation which directly impacts on Selma. someone perhaps should be there to represent what Selma's views are in this litigation.
Thank you, Richard. I want to advance the case scenario we heard from the vignette. Let's suppose for a moment Mom, in her confusion, in confusing her neighbor as her late husband, is having unprotected romantic relations with her neighbor. Let's say she doesn't have the capacity to be careful. Let's say she's giving her money away. I'd just like a show of hands. Does anybody think she's acting in her best interest? I don't either. So what I'd like to pose to Section 3 Counsel, and Marshall, I'm going to start with you, and then I want to open it up to all the table. As far as the role of the Section 3 Counsel, if you believe, when you speak to Mom, that she's being taken care of, taken advantage of, and more importantly, that she's at risk, do you think Section 3 Counsel should still present her views to the judge? Do you think it's up to Section 3 Counsel to advocate for those views? Or do you think you have a moral obligation to say, I don't think that Peter should come by and have unsupervised visits with Mom?
The question is obviously one that makes some of us uncomfortable, and it's important that we appreciate the role of Section 3 Counsel, which is to advocate for Mom's wishes. So firstly, with respect to unprotected romantic relations, I think, but for that particular activity, none of us would be here other than those who were conceived in vitro. So I think that we have to appreciate that there are things that people do that are not necessarily in their best interests, but capable people are entitled to do things that others might say are not in their best interest. So the key question in respect of sex in particular is capacity. Because if someone is capable in respect of sex, and we'd have to determine how we work that out, then they make their own decision and nobody should be interfering with it. On the other side, sex is one of those things where if someone is incapable of making the decision, incapable of giving consent, appreciating what the nature of the act is, that it has a sexual nature, etc., then that person actually cannot have sexual relations. It's not possible for someone else to make that decision for them. So it's a very important decision to get right. But that said, as counsel for Selma in this case, my role would be to advocate that if she wishes, she can continue to have sex. She can, in fact, assert that she is capable of making that decision, and my role would be to do that. Not halfway, not in any way that suggests that there should be some protections in place if she doesn't want those. It's really up to her if she's capable.
One other thing I'd like you to comment on, because I think it's important. There's a section in the Substitute Decisions Act that talks about the capacity of your client. Can you go into that, please?
Well, in Section 3, the client is deemed capable of retaining and instructing counsel. Now, I want to emphasize something that Richard just said before me, which is that there's no special aura around Section 3 counsel. Section 3 counsel is simply counsel. A lawyer who is engaged to represent and I'll say the word interest in the broadest sense, I'm not going to use the word best interest because there's a big distinction, the interests of the person for whom they're appointed. Ideally, that person would go out and retain counsel themselves. And it's only because they haven't done so that the Act provides that the court can direct the public guardian and trustee to arrange for representation. But the role is no different. The client, if the client agrees to have counsel, if the client gives instructions to that counsel, that person is counsel with all the obligations of confidentiality, of loyalty, etc., to represent the interest as expressed by their client's own wishes.
Andrew, do you have anything to add?
I think you've got to remember, Charles, that I'm not the only person in the courtroom who's there with my client, the supposedly incapable person. I mean, son and daughter are going to be there as well. So if they want to make the argument about what's in mom's best interest, what they view that is in mom's best interest, they're there to do that. That's not my job. My job isn't to bring my view of what's right for mom before the court. My job is to bring mom's view, mom's information as much as possible, as much as she's able to give it to me. That's my job to do that. If others want to argue about best interest, what they perceive it to be, they're there. It's not an empty courtroom. There's other people there to do that.
And do you think it's your role to present mom's wishes? Because mom might say, I don't know who the man is, but I like it, and I don't need my money. I want to give it all away to him. Do you present those views, or do you advocate for the autonomy of the elderly? Do you say it's up to them what they want to do?
I think the two go hand in hand together. I mean, an autonomous person can give their money away, even if they're mistaken about that. That's not for me to decide. There's a judge. We've got to remember, we're in a courtroom at this stage. There's a judge who's making that decision, a judge who's listening to what I have to say, what my client's instructions are, what my client's wishes are. There's a judge who's listening to counsel for Saul, counsel for Emily, whoever else is there, and they're the one ultimately making the decision.
I'm throwing this out to the both you and Marshall. Do you ever have qualms that because you're so good at your job that you may succeed and that your client may be worse off for it?
No. and no one would disagree with me on that either here.
I'm not quite as unequivocal as Marshall. Yes, there are times, but that's what my job is, and my role as an advocate, I have to make that the primary thing.
And Richard, as a public guardian trustee, if there were such a situation where you saw the counsel for the allegedly incapable person was really doing a wonderful job and persuading the court to follow what might be in the, or is likely going to be not in the best interest of the allegedly incapable person, what is the role of the public guardian trustee? Would you get involved?
It is only in rare circumstances that we would get involved. This one doesn't appear to be one of them. I just want to take a step back and go back to the Substitute Decisions Act, which there are two thrusts within it. I just want to refer everyone to Kim Whaley and Amina Sultan's paper, which is at tab 14 of the materials. It's a good read. It also references Marshall's paper on Section 3 Counsel. Thanks to them for allowing me to use that paper. It's saved me so much time in writing my own. But in that paper, it mentions that there are two broad thrusts in the SDA. One is for the protection of the vulnerable, and within that is the best interests of the vulnerable. But the other element is the autonomy of the vulnerable, and I would suggest Section 3 falls into the latter. You are having this person's voice heard to the court. The court will decide eventually what may be in the person's best interest. In so doing, other people can file whatever evidence they want in response to Selma's evidence. I think it would be interesting to see the evidence saying that, someone's having unprotected sex and what the direct risk is. You'd have to know about Tony's particular circumstances in that avenue. But in any case, I don't think it's only Section 3's counsel that has a say in the court proceeding. It's everyone, and at the end of the day, a judge will make, hopefully, the best decision. Once again, I don't think the PGT has a particular role so far. And the reason I do say that is, as my colleague from the Children's Lawyers, Sue Stam, observed, in many ways, the court does rely on the PGT's opinion. And more significantly, a lot of the litigants want us to take a particular side. I mean, I'm sure here with the siblings, you know, each sibling would want us to say, the PGT to say, you know, this is not in Selma's best interest, but we really don't know Selma. We don't know what her relationship is with Tony. We do know that it's important for Selma's voice to be heard, especially when other people are making allegations regarding her relationship, something that we as non-vulnerable people take for granted. No one questions our bad decisions in many of the relationships we may have made. You know, we want Selma's voice to be there. That would be our chief role.
So let's say Saul comes into our office and he's in this situation where he's really concerned about Mom. What could Saul do? Marshall, if he came into your office?
So changing hats and seeking to advise Craig Vanderzee, which takes some doing. You would want to look at objective standards. You would want to avoid the discomfort that sometimes we have in simply discussing sexual relations amongst the elderly, and we'd have to try to look for something objective. So we'd see what medical evidence there is with respect to capacity generally. We would try to engage experts to see where Selma is on this threshold and try to put that evidence forward. So seek a function-specific capacity assessment if that can be arranged. You know, first we'd have to determine what at law is the test for capacity, and then we'd have to have some type of professional apply it for us. But to jump the gun, to put Selma in a position where she can't go within 100 meters of Peter or Tony, that is a concern because it restricts her liberty as much as you would want to sweep in and be protective. There's a risk of being overprotective, restricting her liberty, getting her very unhappy, and interfering unnecessarily when, if, for example, we were to seek an injunction and then seek to enforce that injunction, which might be granted, and there are cases where those kinds of things, orders have been granted, we might be overstepping before we've looked at the capacity issue first.
Andrew?
But you got to be careful with the guns a-blazing kind of approach. And Marshall was talking there about injunctions and things like that. And yes, you can enforce those. And Susan Greer was talking earlier today about contempt orders or the criminal ability that you have. But that's really going to rip what's left of the fabric of this family apart. And I think that, you know, if we're at the same stage we came to this table at, where Jordy's almost got Saul and Emily hugging, to now to rip away at the fabric there and to go after Mom. But because an injunction against the boyfriend is an injunction against the mom. And that's certainly not going to put her in a very good framework with her son. There's certainly going to be a lot of animosity there. And in her last years, especially as she seems to be declining, that's certainly not what the mission really should be here. There are other ways to approach it, and Marshall talked about those. One of the other ways of doing that is perhaps some sort of an ability to restrict cash flow. Let's find out if Petey's really there for love or if he's there for the money. If you cut off or restrict, not cut off, but put some limits perhaps on what money can go out to Petey, that might really show what's going on. It would protect Mom from the financial perspective and really show Petey's true colors.
It's interesting. I have a somewhat different perspective. If a client comes to me and says, my mom is totally vulnerable, she doesn't know what she's doing, and she is physically at risk, because we know if you take a look at the studies in nursing homes, for example, there's a high degree of STDs. She's at risk. I think I sit down at my desk, do the research and see what I could do to protect Mom, because I think the thesis statement of the Substitute Decisions Act is what's in the best interest of the allegedly incapable person. I respect the autonomy of people to make their own decisions, but when they've lost the capacity to protect themselves, I think that's up to her children who are left. Just one more comment before I pose my question to Rabbi Torczyner. Not all of this is going to be altruistic always, right? Because let's not forget what happens, guys, when mom remarries Peter. Who's the first loser? The kids. Because any will that Mom had beforehand is going to be automatically revoked. She doesn't have the capacity to make a will, so she'll die, and when she dies, she'll die intestate. And the first $200,000 will go to her new spouse, who may very well be the financial predator she has to be protected from. Rabbi Torczyner, I want to ask you how you would have responded if the brother and sister had come to you to help mediate and resolve their dispute, if their benchmark was not the Substitute Decisions Act or the common law, but Jewish religious law halachically. For example, when does Mom lose her rights to make her own choices? When does the obligation of kibud ava aim, to respect and fear a parent, take over as opposed to honoring a parent's wishes? And do children lose their right to decide because they have that conflict of interest I mentioned before, where maybe their views are being colored because they don't want to lose their inheritance?
Well, I was looking forward to disagreeing with everybody on the panel. Will I get to do that later, after I answer about the kids?
No. Why don't you tell us first why you disagree?
Okay. Well, first, just on what you said at the end about the thesis of the Substitute Decisions Act. If I understand correctly, you're talking about something that's different from what they're talking about with Section 3 counsel. Because what you're talking about is looking out for the best interests of someone who's incapacitated, but the thesis of Section 3 counsel is that their capacity is an issue, but they have not been declared incapacitated. So yes. I think that's an important distinction. But now I get to disagree with everybody else. Richard made the point, and clearly correctly, that there's an elementary unfairness to the person whose capacity is an issue by saying to her, we are now appointing a lawyer for you, and by the way, you're also paying that lawyer. But there's also, I think, a fundamental unfairness to the lawyer in saying, and now you are responsible to carry through all the wishes of this person whose capacity is an issue, no matter how bad you think the decision-making is, or maybe not no matter how bad, but to a great extreme. While it's true that people are entitled to disagree with each other, and she has her fundamental freedom to make decisions that are not going to be questioned by people she does not know, has never met, and has no interest in having them review her decisions. At the same time, it's central to Judaism that the individual has a responsibility, number one, to help prevent other people from getting hurt, and number two, to prevent herself from harming other people. The challenge of professional ethics in many ways, certainly from a Jewish perspective, is that you have to introduce your duty to your profession into the hierarchy of other duties that you already have. Duty to self, duty to society, duty to God. And it's especially complex when you deal with law, because duty to law is also duty to society, and from a Jewish perspective is also duty to God. The justice being a very important value within Judaism. So it makes for a very complex hierarchy of ethics. Take a separate case, the issue of confidentiality. Right? The argument can be made that when you look at the rules of professional conduct, a lawyer who knows that her client is doing something which is going to harm somebody else, may cause them to lose their entire retirement fund. That lawyer is not entitled to say anything. I could know as a lawyer, I'm not a lawyer, but if I were a lawyer, I could know that my next door neighbor was about to lose her retirement funds because of something my client is doing. I have no ability to disclose it because of confidentiality. But you can make the argument that it is more important for society as a whole to have a legal system that upholds confidentiality than it is for me to protect my neighbor. That argument can be made, and therefore I have to hold back and not speak up and not do anything to prevent this from happening, because what I'm really doing is supporting society's legal system, and that's a good thing. But I think it's harder to apply that when you talk about a lawyer acting in a way which could actively be harming the client, where the lawyer believes not just that this is an ill-advised relationship, but where the lawyer actually believes that this is rape, and that by failing to do anything to prevent it, the lawyer is actually, or worse, putting forth an argument to justify the relationship. The lawyer is considered to be part of that. Now, I think it was Andrew who pointed out the lawyer is not the only one involved. There are the children. There is, a system of adjudication. It's not as though the lawyer is the one who's the sole agent of this. And in Judaism, we do distinguish between direct action and what's called in Aramaic grama, indirect causation. And for an indirect role, there's a lesser degree of liability. Nonetheless, speaking from a Jewish perspective, not necessarily speaking from a perspective that the Law Society is going to accept, I think that the lawyer does not check personal values at the door, and the responsibility of not being an agent of harm, where you actually believe that it's harm, not just we have different set of values and I think this isn't what you should be doing, where you actually believe that your actions could cause her to be hurt. I think there's a need to consult Rule 3.7 to ask the question of when am I entitled to withdraw, to go into some form of consultation with experts about the possibility of withdrawing in a way that does not leave the client in a worse state, but allows the lawyer to retain personal ethics. Should I switch over to the children now, or wait for the lawyers to tell me where I've got it wrong?
I think it's a pretty informal discussion, and I see Marshall is taking copious notes. So, do you have some comments?
I do want to point out that there are exceptions to lawyers' obligations with respect to confidentiality, so that if we do have a situation where confidentiality or maintaining confidentiality may result in serious bodily harm, as an example, then to the minimal extent required to prevent that outcome, a lawyer is relieved of the obligation of confidentiality. So it's not absolute in that sense. So I don't want to suggest that everything is black and white, because there are nuances here. And also with respect to withdrawal, I mean, you have to look at the whole picture. If there's no breakdown in that lawyer-client relationship, that relationship should probably be maintained. And again, we are in a system where it is not the role of the lawyer appointed or retained by a person whose capacity is at issue to be judge and jury.
Right. Entirely agreed on all the points.
The only other thing I would add is that, aside from withdrawal, is before you're actually retained. And the way it typically works, Richard, you can correct me, is that Richard, or the PJT, would contact the proposed Section 3 lawyer and give them a basic overview. This is the case, this is what's going on. Are you able to act as counsel for the allegedly incapable person? And if there's some issues that you have on a personal basis off the bat, you might have some personal problems with the kind of issues at stake, you can say no. Richard's got other people on his roster that he can choose, so he wouldn't even get involved in the first place. Mm-hmm. That option is always there.
Great.
Do you have any comments, Richard?
No.
Okay. So, Rabbi, why don't you continue with what you would advise the children?
Okay, sure. When it comes to the children, and this I put in the paper, the focus is not only on what the mother's rights are, but it's also about the child's responsibility to assist the parent, and that applies even where the parent has capacity. The fact that a parent is able to make their own decisions and has never been questioned in that regard doesn't stop children from having a responsibility where they have sufficient expertise, know-how, to know what they're talking about, to be able to offer their help. Judaism in general, as is probably well known to the people in the room, frames the life of the individual on two levels, as an individual and as a citizen, a member of society. And the challenge of ethics is for me to decide how to balance my responsibility to myself versus my responsibility to the community. In the case at hand, the child has, on the first level, a duty to rescue any individual from harm's way. The biblical verse, Lo ta'amod al dam re'echa, don't stand by while someone else's blood is shed. So that's a responsibility to anyone, family or not. Second, there's a responsibility to look after the welfare of one's family. And then third, the innermost circle, the responsibility to look after one's parent. You pointed out the possibility that helping a parent may actually trespass against the requirement to honor one's parent. But Judaism, generally speaking, looks at preserving the welfare of a parent, health, financial welfare, dignity, as part of honoring them. So, what I'm doing is to use the phrase that Marshall used, I'm painting something rather black and white that isn't. The truth of the matter is that it's very gray in terms of the implementation of it. But the child is certainly going to have a responsibility to find a way to help the parent. And if the child wants X and thinks that this is what the parent ought to be doing and the parent wants Y, the child's going to have to think long and hard, potentially consult with those older and wiser, more experienced and wiser, and ask them, ask them for guidance on how to proceed. But the child does have a responsibility to look out for that parent.
Okay. Thank you. At this stage, what I'd like to do is I'd like to invite all our presenters to the podium. There may not be enough room for everybody, but we'll try and fit in and give the audience a chance to ask some questions.